thank you, first of all, for joining us for what we hope is the first in a series of product liability webinars. I'm going to be focusing on Section 41(1) and strict liability claims, and Alistair Mackenzie, in about 15 minutes' time, is going to be considering Brexit and its impact on the Consumer Protection Act. We are very happy to take questions if you want to post them in the Zoom software. Otherwise, feel free to email us at the end of the seminar. And we do have slides which we can make available to you at the end of the webinar as well, if you want to email us and ask. Finally, I would ask you to mute your microphones if possible, because otherwise we're going to have background noise from everybody, which could make things difficult for people to understand. So then, why Section 41(1) now? There are two reasons. Firstly, in my view, it's an undervalued and potentially very useful route to recovery if you are the right type of claimant. And the second reason why I decided to focus on this particular topic is that I appeared in the case of Wilson and Beko, led by Charles Dougherty QC, which was handed down in December of last year, and which was the first case to consider whether or not a consumer claimant could bring a claim under Section 41(1). There are three areas of this particular webinar. The first is that I want to briefly look at the scope of Part 1, and that's something with which I know you're familiar, but it's important when we consider the context of Wilson. Secondly, I want to look at Section 41(1) and Wilson in more detail. And thirdly, I want to look at the ways in which non-consumer claimants can use this provision to bring such claims going forward. So firstly then, Part 1 of the CPA. Some short points to make. The first is that it implements the Product Liability Directive. The second is that its broad effect is, of course, to make producers, importers, and in very limited instances, suppliers, strictly liable for damage that falls within its scope caused by defective products. What do I mean by damage that falls within its scope? Well, first of all, we have personal injury and death, and claims can be brought regardless of the status of the consumer. For example, if you had an electrician who injured himself whilst on a sole trade job as a result of a defective product, he would be able to bring a claim under Part 1 of the CPA. Conversely, however, there is a distinction drawn in relation to property damage. Property damage which is intended for private use or consumption, and which was in fact used by the injured person mainly for his own private use or consumption, does fall within the scope of Part 1 of the CPA. The paradigm example would be, of course, a consumer whose house is destroyed as a result of the washing machine catching fire. But that, of course, excludes non-consumer claims for property damage. So a business whose factory goes up in smoke wouldn't be able to bring a claim as a result of a defective product, wouldn't be able to bring a claim under Part 1 of the CPA. The final point to note in relation to Part 1 is the 10-year long stop. Precisely when time starts to run in relation to the long stop is, and indeed could be, the subject of a future webinar. It's very complicated. But for the purposes of today, let's assume that the 10 years begins when the finished product exits the manufacturer's gates. A claimant then has 10 years from that time in which to bring a claim. That, of course, provides some certainty for manufacturers who can assume that they won't be facing claims of that nature after a 10-year period. But it can provide difficulties for consumers who may not suffer damage until after that point. Moving on then from Part 1 of the CPA to the other parts of the CPA. The rest of the CPA deals with matters separate to the directive. So it's just Part 1 which deals with the directive. Section 11, which falls into Part 2 of the CPA, enables the Secretary of State to make safety regulations for the purposes, amongst other things, of securing that goods are safe. And these regulations cover a huge range of things, including toys, medical devices, pedal bicycles, furniture, motor vehicle tyres, cosmetic products, electrical plugs, road brake linings, fireworks, pressure vessels, personal protective equipment, and pressure equipment. More practically for our purposes, there are safety regulations which relate to gas appliances and indeed to electrical equipment. Now, breach of those regulations can amount to a criminal offence, but again, more pertinently for our purposes today, breach might be actionable under Section 41(1), to which we will now turn. And Section 41(1) appears in Part 5 of the CPA. Section 41(1) then provides that an obligation imposed by a safety regulation shall be a duty owed to any person who may be affected by a contravention of the obligation. And it goes on to provide that contravention of any such obligation shall be actionable accordingly. Pausing there then, 2 points to note at this juncture. The first is the section provides for strict liability, and the second is to ask, to whom is this duty owed? Well, the potential claimants appear at first glance to be extremely wide. There is no restriction, for example, in relation to non-consumer claimants and property damage, provided that is covered by the relevant safety regulation. And indeed, non-consumer claimants have attempted, and in one instance have succeeded, in bringing such a claim. There are 3 reported cases on this particular point. The first is Howmet and EDL, where the case failed as a result of causation. The second in time is Stoke-on-Trent and Pelican Rouge, where the case was successful, and I'll return to that at the end of this talk. And the third is the case of Good Life, food and hall fire protection. That claim was a strikeout application, and the application couldn't get very far because, unfortunately, the product in question didn't fall within the safety regulation. What then about consumer claimants? From the wording in section 41(1), which, as I've noted, is very broad, it seems prima facie that consumer claimants would be able to bring a claim under that particular provision. Well, that is precisely what the court had to consider in the case of Wilson and Beko. In that case, the claimants were focusing on the Electrical Equipment Safety Regulations 1994, which I will refer to after this point as the 1994 regulation. The claim arose out of a residential fire, and tragically, the fire killed one of the family members, injured others, and destroyed the family home. The claimant's case was that the fire started in the fridge freezer, which was manufactured by the defendant. The first point to note is that the claimants could not bring a claim under Part 1 of the CPA, as the long stop period had passed. So instead, they tried to bring a strict liability claim under Section 41(1), together with the 1994 electrical regulations. Mr. Justice Julian Knowles ruled, accepting our arguments, that Part 1 of the CPA and the Product Liability Directive provided for an exhaustive system of liability within their scope, which precluded any other form of strict liability claim. And the judge held that the directive, as it had been interpreted by the ECJ on a number of occasions, was intended to provide a maximal level of harmonisation in relation to defective products based on strict liability. It was therefore not open to member states to provide for a system of protection based on no fault, which was wider than that provided for in the directive. And he held that the claimant's claims fell squarely within the scope of the directive and the CPA, and therefore could not be said to be based on other grounds to that of the directive and the CPA. Now, the claimants also argued in the alternative that they fell within the exception provided by Article 13 of the directive. Article 13 of the directive provides expressly that the directive does not affect any rights an injured person may have on the basis of any contractual liability. So somebody would also be able to bring a contractual claim in addition to a Part 1 CPA claim, or non-contractual liability other than that provided for in the directive. And that's commonly understood to mean a case in negligence, which is why you often see a claim under the CPA and simultaneously a case in negligence. There is then a further possibility under Article 13. It provides that the directive shall not affect any rights an injured person may have on the basis of a special liability system existing at the time the directive was notified. The claimants argued that Section 41(1) and the 1994 regulations constituted a special liability system. Now, the judge held against them on that, and he held that Article 13 only referred to the special system put in place by the German government in response to the thalidomide crisis. The claimants are appealing that specific point. That's going to the Court of Appeal at some point in the future. And we are asking the Court of Appeal to uphold the judgment on the additional grounds that Section 41(1) and the 1994 regulations do not constitute a special liability system which was in place and existed at the time the directive was notified. As that is going on appeal, that's all I will say about it for the moment. But suffice to say, at present, it appears that non-consumer claimants cannot bring a claim under Section 41(1) of the Consumer Protection Act. But what I want to do in the final third of this webinar is to look at non-consumer claimants and the ways in which they might be able to make use of this provision. The first thing you need to do is, of course, to check whether there are any relevant safety regulations which apply. The ones which have popped up most frequently in my instructions are the safety regulations dealing with electrical equipment and gas appliances. And indeed, for the purposes of today's webinar, I'm going to focus on the 1994 regulations which relate to electrical equipment. They have been the focus of all the reported cases to which I have referred: Howmet, Stoke-on-Trent, Goodlife, and Wilson. So what about the detail of those regulations? Well, Regulation 5.1 essentially provides that electrical equipment shall be safe. And Regulation 14, in essence, provides that no person shall supply electrical equipment which doesn't satisfy Regulation 5.1, i.e. that supplies equipment which is unsafe. Now, what about the meaning of safe? It has the same meaning as Section 19.1 of the Consumer Protection Act, which essentially provides that there shall be no risk, or no risk apart from one reduced to a minimum, that the following will cause death or personal injury: the goods, the keeping or use of the goods, the assembly of the goods, the emission or leakage from the goods, or reliance on accuracy of measurement of the goods. Now, you will of course have spotted that Section 19.1 makes no reference to property damage. But Regulation 3.1 of the 1994 regulations provides that a reference to risk shall be construed as including references to any risk of damage to property. Well, who then is liable? Anyone who supplies such unsafe goods. So the pool of defendants is potentially a great deal wider than under Part 1. As you will recall, at the beginning of this webinar, I mentioned that suppliers are only liable in a very limited scenario under Part 1 of the CPA. Well, under Section 41.1, any supplier is potentially liable. So it's potentially an extremely useful route to recovery for a non-consumer claimant. How about the defences available under the 1994 regulations? To some degree, defendants have fewer defences than under Part 1. They do not have the capacity, for example, to raise the controversial development risks defence. Conversely, if you go back to the definition of safe in Regulation 3.1, it excludes risk arising from the improper installation or maintenance of the electrical equipment, or the use of the equipment in applications for which it is not made. Now that, to me, seems to be a better position in some ways for the defendant than under Part 1. You will recall that the test for defective under Part 1 requires the court to take certain circumstances into account, including what might reasonably be expected to be done with or in relation to the product. So in my view, that means if a product is likely to be misused, the manufacturer needs to take steps to prevent that from happening. So for example, a laptop which might catch fire if it's left on a bed and the relevant fans are not left uncovered might need to provide a warning that it should not be left in such a fashion. What then about limitation? Well, the 10-year long stop seems unlikely to apply, and that appears to be the case, for example, in Wilson and Beko. That was the decision of the judge. And in my view, it's highly likely the other slightly idiosyncratic limitation periods in relation to Part 1 would also not apply. So under Part 1, you have 3 years to bring a property damage claim. Well, it seems to me likely consistent with the reasoning in Wilson that would not apply to Section 41.1 claims. And that indeed was the conclusion of the Honourable Mr. Justice Stephen Davis in Goodlife Foods, albeit that was on a strikeout application. He found that the argument that the limitation periods of Part 1 shouldn't apply to Section 41.1 met the test for a strikeout application with a comfortable margin. Now, for a successful claim under Section 41.1 and the 1994 regulations, I would urge you to look at the Stoke-on-Trent and Pelican Rouge case. There, a commercial claimant had suffered a fire in a college building, which had started in a vending machine, and they brought a claim against the supplier of said vending machine. One of the routes in which they did that was under Section 41(1) and the 1994 regulations. And Stephen Davis, again, held that the defendant was liable under Section 41(1) and the 1994 regulations. So that's a useful case to cite in your letter of claim if you're writing to a particular supplier. Inevitably, these particular claims are going to throw up very specific queries, particularly if you're looking at another set of safety regulations. So if you have any more specific questions, please do not hesitate to get in touch afterwards. Other than that, I will hand over to Alistair, unless he has any particular questions that he would like me to deal with.
Well, Isabel, I think since you've not had any questions in the chat, it's customary for me to ask you one question just to sort of open it up and see if anyone else feels liberated to do so by my asking. So one question would be, we look at the definition, for example, of safety in 1994 regulations, the electrical equipment regulations. How do we interpret that, or do we interpret that at all by relevance to Part 1 of the CPA and the concept of safety in that legislation?
Well, the matter hasn't been determined directly, but certainly one of the reasons that the judge came to the conclusion that the claimants in Wilson would have fallen within Part 1 and their claims fell within the scope of Part 1 was that he felt the definition of safe and unsafe and the test for defect were similar. One will recall, of course, that the test for defectiveness you have to consider whether or not it's safe such as persons generally are entitled to expect. So in my view, I think in practice, the answer is very likely to be the same, but it's yet to be determined in detail. And other than that,
well, that doesn't seem to have prompted anyone to ask me any burning questions in the chat, but I can encourage everyone to ask Isabel lots and lots of questions over email as soon as this is over. In the meantime, I'm going to, as Isabel said, talk a bit about Brexit and what that means for product liability and product liability lawyers. Just before we start, obviously we're in a real period of uncertainty at the moment. I don't think anyone would have expected that at this stage we would be thinking back to those rosy days of not too distant past when Brexit was the thing that we were talking about all the time, but here we are. I'm going to start by talking about where we are at the moment. Then we're going to look at where we know we're immediately going after the transition period, what can be done in the meantime, and then what further changes might be on the horizon. Throughout this sort of 15-minute talk, I'm going to refer to a few pieces of legislation. I'll get the definitions out of the way at the start, just so you all have at least some idea of what I'm talking about when I get myself mixed up. We've got the European Union Withdrawal Act 2018, so I'll call that the 2018 Act. We've got the European Union Withdrawal Agreement Act 2020, that's going to be the 2020 Act. Then we've got what's referred to as the transition period in the Withdrawal Agreement and the implementation period in the 2020 Act and the legislation under that. So hopefully we've got inconsistent terms. I'll be sure to use those terms completely interchangeably just to make sure it's as confusing as everything else is. And we have exit day, because we shouldn't forget that we have left the European Union. Exit day was on the 31st of January 2020. Currently, the implementation or transition period is due to end on the 31st of December 2020. But the reality is at the moment, perhaps unforeseeably, we do not know whether or not that is now going to be pushed back. The 2018 Act operates in a very unusual and particular way. You'll recall it was at one point referred to as the Great Repeal Bill. The reality is that it doesn't so much repeal EU law as take a snapshot of most of EU law as at the date of what would have been exit under the original legislation. Under the 2020 Act, that's now as of the date of implementation. We'll come on in a moment to how that functions. Unless modified, retained EU law, which is transported into domestic British law by virtue of sections 2 to 4 of that Act, is decided, retained EU law, questions about it are decided in accordance with any retained case law and any retained general principles of EU law. Now, the idea is that, as I said, we have a snapshot and it should continue to function for those retained provisions unless they're changed in the same way. One of the most important parts of the Act, which again we'll talk about in a moment, is Section 8 and Section 9 of the Act, which give broad powers to ministers of the Crown to make provisions by regulation to deal with the consequences of withdrawing from the EU. The 2020 Act works in a number of ways, primarily by changing things around. So Section 1 of that Act inserts a new Section 1A into the 2018 Act, which itself contains what may be the most artificial provision in any recent legislation. The European Communities Act 1972, the law by which effectively Britain's membership of the EU was given effect in statute, was technically repealed as of the 31st of January 2020. And that's what we mean when we say that Brexit has been done. But it continues to have effect with some minor modifications that aren't relevant to anything we're talking about today until the end of the implementation period. And that's why, although it may feel like it at the moment, the planes haven't fallen out of the sky because of Brexit at least, and they won't do so until the 31st of December 2020, if that's what's going to happen. I'm not expressing political opinions right now. Section 5 of the Act provides that rights within the Withdrawal Agreement itself are recognised and available in domestic UK law. Now what that means is that various rights within the Withdrawal Agreement essentially have direct effect in the UK without further legislation. Section 25 of the Act provides that wherever there's retention of EU law that was provided for in the 2018 Act, that's no longer the snapshot being taken at the 31st of January 2020, that's now being taken at the end of the implementation period. And finally, just to tie everything up, Schedule 5, Paragraph 1 provides that references in subordinate legislation to it coming into effect on exit day are in fact to be read as references to the end of the implementation period. And we'll come on to look at exactly what that means by reference to the metrology regulations, which we'll discuss in a moment. As for where we are at the moment then, this is recently summarised by Lord Justice Green in the case of the Queen on the application of Simonis and Arts Council England in the Court of Appeal. He put it better than I can, and he's a Lord Justice of the Court of Appeal, so I won't try to improve upon it. During the implementation period, the doctrine of supremacy is retained. National courts remain entitled to disapply inconsistent national law and should apply the usual principles of interpretation. When construing union law, the courts must have due regard to the case law of the Court of Justice, and the courts have the power to make a reference to the Court of Justice. And in fact, those of you who get regular updates from the Supreme Court will see that there have been a number of references made even over the last few weeks. As he concludes, in short, during the implementation period, the law that applies remains as it stood prior to exit day. So where we are at the moment, for the purposes of our product liability law and for almost everything else, is unchanged from where it was prior to the 31st of January this year. What's coming next, though? Well, as we move to after the transition, we know at least one thing that's going to happen, and that this is going to be amendments to the CPA under the very snappily titled Product Safety and Metrology, etc., Amendment, etc., EU Exit Regulations 2019. All of this legislation that's been introduced in this way has almost impossible titles and is structured in ways that make it needlessly complicated, but these regulations may take some of the biscuit unless you've had to examine any of the chemical regulations. Regulation 6 and Schedule 3 of those 2019 regulations provide for amendments to the CPA. Now, those changes are limited, but they are significant. Importantly, Section 2.2 of the CPA is amended, as from the 31st of December 2020, in order to provide that rather than a defendant being a person who's imported a product into a member state from a place outside the member states, a relevant defendant is a person who's imported a product into the UK from outside of the UK in order in the course of any business of his to supply it to another. Now, the reasoning for this makes sense in the context where we're leaving the single market. We are looking to identify who has brought a product within our own new, smaller market. However, the most important point to note about these regulations at the moment, and as we approach the end of the implementation period, is that there are no transitional provisions within the 2019 regulations. We do not know, and we can only guess at present, as to who the correct defendant is, where we have a product which is imported prior to the end of the implementation period, but the damage doesn't occur until after the end of the implementation period. We do not know who is the correct defendant where a product is imported and damage occurs prior to the end of the implementation period, but the claim is not issued. The assumption is always that legislation is not retrospective, but when we talk about legislation not being retrospective, what we mean is that legislation shouldn't change the legal nature and consequences of an action or event that occurred prior to the legislation coming into effect. But if that's to be the case under these regulations, and neither the legal nature of the import should change, nor the legal consequences of the damage should change, then that means that any person who finds themselves damaged by a product that has been imported prior to the transition, but the damage only occurs after, will find themselves potentially without a remedy against any domestic producer, person who's held themselves out, or importer. That's clearly not what's intended, but what we don't know at present is what the solution will be. The other changes that are contained within Schedule 3 are also significant. At paragraph 4, the schedule limits the defence which is available under section 4.1a of the Act. That's the defence that says it's a defence to an action if a product is defective only because that defect was necessary as a result of complying with an EU law obligation. That's modified under Schedule 3 of the 2019 regulations to provide that that only applies insofar as the EU obligation is one that's been retained. Now that sounds like a minor change, but it has consequences in particular for defendants who are manufacturing products and they're doing so in order to comply with new EU regulations, new EU directives, in order to make their product marketable in the EU. But if that obligation is not a retained obligation, because, for example, it's been introduced after 2020, then they will not have a defence in the UK where they would have a defence in Europe. And so we already see where this creeping misalignment of regulation is going to start having real effects in the product liability sphere. The other important change that's introduced by Schedule 3 is that the power at Section 8 of the CPA to modify that Act by ordering Council by secondary legislation in order to comply with any modification of the Product Liability Directive is revoked. Again, this makes sense given that we are not going to be complying with, we are not going to be having the effect of, unless we choose to, any subsequent change to the Product Liability Directive. But it is an important point to note that we will no longer be automatically keeping track, and the government will no longer have the primary power under that provision to keep us in track. However, as we move post the transition, we need to think about as well what the effect will be of EU court decisions on the decisions of our own courts. If there is a new decision after 2020 by the CJEU as to the scope of the development risk defence, the meaning of defect under the directive, then that is a matter which the UK courts can have regard to. If a decision is taken by the CJEU, by another EU entity, or by the EU itself, the UK can have regard to it, but the courts are not bound by it, and in particular, the Supreme Court is no longer bound by any CJEU authority. They can choose to depart from it in the same circumstances as they made from their own decisions, and that's in Section 6.2 of the 2018. So what can people do in order to prepare themselves for the transition? Well, the most important people to find themselves really doing things that are proactive are people who are importers into the UK from the EU and other distributors. Because the first thing that they will want to confront as a reality is that their potential product liability going forward is going to be much greater. The first step is, of course, to ensure that there is appropriate insurance in place. The scope and the potential for being made to pay damages as a result of products is going to vastly increase because they will become a primary defendant to CPA actions. The other thing that importers should do is consider their contracts with EU suppliers. Now, many wholesalers may have contractual clauses designed to protect them against claims by those they sell directly to. For example, a limitation clause to your down-the-chain shop that you're selling to as a wholesaler. But your up-the-chain contract may need to be re-examined, and you may have to look at what, in fact, limitation clause or exclusion clause is there, because if your CPA action by the consumer who couldn't sue you before but now can is brought, then that consumer and their claim against you won't be affected and won't be limited by any such terms. The other thing to note, it's potentially less relevant for the talk today, is that there will be extensive new labelling requirements for such importers and distributors. As we go beyond this, though, that's what we know is going to happen immediately after the transition period. As we go beyond this, there's no pretending that we're doing anything other than slightly looking into our crystal ball and trying to divine what will happen going forward. That's probably harder now than it ever has been. The first thing to note is that, as I said, the power to amend the CPA to keep track with changes to the directive has been gone. Section 8 of the CPA has been removed. There is a new, broader power in the 2018 Act, which is a significant shift in our constitutional arrangements, and these are the Henry VIII powers that were vastly discussed at the time the 2018 Act came in. These provide that a Minister of the Crown may, by regulations, make such provision as the Minister considers appropriate to prevent, remedy or mitigate failures of retained EU law or any other deficiency in retained EU law arising from withdrawal of the UK from the EU. Now, there are a number of potential ways in which retained EU law can be deficient, and these are defined at section 8.2 and 3. Many of these include redundancy, so it's no longer a necessary provision, or the fact that the provision was founded on reciprocity. But an awful lot depends on what is classed as being appropriate going forward, and there's no definition given of what exactly will amount to appropriate. So these are wide-ranging, not incredibly well circumscribed powers that Section 8.5 makes clear can make any provision that could be made by an Act of Parliament. So that means they can modify primary legislation, even repeal it. However, the explanatory notes make clear that the law is not deficient merely because a minister considers that EU law was flawed prior to exit. So simply because a member of the cabinet or another minister decides that actually the EU never should have introduced this law and it's a bad law, doesn't mean they can make a change under Section 8. What this means for us going forward is that we are all public lawyers now, because every change that's introduced, and there will be thousands upon thousands introduced by virtue of Section 8, every change that's introduced will not be primary legislation, it will be secondary legislation. That means it's open to judicial review and probably more likely relevant for these purposes, for product liability purposes. It's open to a defence of collateral nullity. So you can say that, in fact, the legislation that's relied upon against you, or the change that's said to be made to the primary legislation which prevents you from bringing your claim or defending your claim, is a nullity because it should never have been made. And that represents really just a very broad scope for having arguments. As to further changes, Parliament now, for the first time since the introduction of the Product Liability Directive, has licence to introduce a new product liability regime or make sweeping changes to the current regime as it sees fit. The first question is, given that we've removed Section 8 and the CPA power to keep track in that way with the Product Liability Directive, to what extent are we going to harmonise and remain harmonised with the EU if its standards change and if it's questions of when an action can be brought changed? Consumer and business lobbies can now seek, in a way they couldn't before, a rebalancing of the picture in terms of product liability. And it's to be expected that both sides will make fervent pushes in order to make this happen. The precise approach that's taken is probably going to depend on the kinds of arrangements that we strike internationally. And one thing to think of in this regard is, for example, the pharmaceutical lobby. Now, it's unlikely that we have a specific carve-out and specific legislation dealing with what the consequences are of suffering damage from chlorinated chicken. But if we're striking a large trade deal with the US, then it's likely that there may be some pharmaceutical implications of that. And one thing that it's perfectly possible to see happening in the not too distant future is a fragmenting of what's currently a unitary regime of consumer protection and product liability, with different regimes for different types of products. So, for example, there may be some kind of argument about something akin to FDA preemption in the USA. And that's really going to be an area where potentially we just will see enormous changes. I'm going to wrap up now, subject to Isabel or anyone else asking questions in the chat. Thank you so much all for coming and for joining us today. This is intended to be, as Isabel said, the first of a series of lectures from the 2TG product liability team. We'll try to keep you occupied in whatever the nature of your product liability practice. There will be talks during this shutdown that suit everyone from life sciences to electrical appliances and industrial products. Future talks that are coming up are going to include practical tips for group actions, looking at the recent Vedanta decision, dealing with learned intermediaries, identifying defence in NHS claims, evidence in electrical wiring claims, and everything else you can think of. But what I should say is if there's any topic that you are interested in, then please just get in touch and let us know. We're probably in a uniquely good position right now to be able to actually deal with things. So unless there's any questions, then that will be all from me.
The final point to note, just for those joining the video and not live, is that our email addresses will be at the end of the video and are, of course, also on our website. So if you have any further questions, then really feel free to get in touch and just email us.